In this module, we will take a brief look at advanced directives and their applicability within the EMS environment. Once completed with this module, you should be able to explain advanced directives and how they impact patient care. This module addresses legalities related to advanced directives. In providing this information, nothing in this presentation should be construed as legal advice. Rather, the information provided is merely a broad overview of this legal subject as denoted within the National Paramedic Educational Standards. Please be aware that every state has different laws that impact EMS agencies and providers, and these laws may change over time by application of legislative action or court decisions. Federal, state, and local laws and other legal provisions not discussed within this presentation may also impact EMS agencies and providers. Additionally, information that was current or applicable at the time this presentation was produced may not be at the time you are watching this presentation, and new laws may have been added as well. Lastly, the legal topics and doctrines discussed within these presentations are not the totality of all laws that apply to EMS agencies and providers. There are numerous other laws and provisions that impact diverse aspects of providing EMS. If you or any other EMS provider has questions related to the laws that apply within the realm of providing EMS, additional guidance and assistance should be obtained from a licensed attorney within your area who has subject matter expertise in the specific area of law in question. In an earlier module, we talked about consent and a patient's right to personal autonomy and self-determination in their healthcare decisions. Over time, our society has begun to recognize the impact of better health care, longer life expectancies, and medical advances on end-of-life decisions. We now have technology to keep a person's body and organs functioning even if they are considered brain dead with no reasonable probability of recovery. There are some cancers where the treatment is arguably worse than the disease itself, and some have even argued that we treat dying pets with more respect and dignity in their last hours than some people. To euthanize a dying pet is considered humane, yet a dying relative in considerable pain with no hope of recovery from a serious ailment or disease is often denied the opportunity to die with dignity. Invariably, end-of-life decisions and the debate related to taking affirmative steps to terminate a life or allow someone to die without having to go through unwanted medical procedures are not the purview of this particular presentation. Rather, we need to objectively look at the laws as they are written so that EMS providers know how to function when faced with a patient who does not desire heroic measures to prolong his or her life. To this end, Congress passed the Patient Self-Determination Act in 1990 to ensure patients' rights to self-determination in healthcare decisions be communicated and protected. Under the law, certain healthcare organizations, such as hospitals, skilled nursing facilities, home health agencies, hospice programs, and health maintenance organizations must provide patients with a written summary of their healthcare decision-making rights and the facility's policies with respect to recognizing advanced directives. These same entities must also ask the patient about advanced directives and update that information within the patient's medical record. Covered organizations must train their staff on these requirements, and it is prohibited for them to discriminate against patients based upon whether or not they have an advanced directive. Notice that the word organizations is used throughout this description. That is because the requirements of the Patient Self-Determination Act do not apply to individual physicians. A critical facet of the Patient Self-Determination Act is that it relies upon the laws of each state to define the legal requirements for advanced directives. Thus, the implementation of advanced directives by any particular healthcare organization are defined by individual state laws. With that being said, the three most common advanced directive instruments for conveying a patient's wishes to healthcare providers are living wills, power of attorneys for healthcare, and do not resuscitate orders. A living will is simply a document that is designed to go into effect if the person completing the document has a debilitating incident that prevents him or her from conveying his or her wishes to healthcare providers. The document is typically idle without any impact or effect until a specific type of medical event occurs, at which point it can then provide legal direction to healthcare providers as to what the patient's wishes are related to his or her care. A durable power of attorney, specifically one related to healthcare, is a document that gives someone else the authority to make healthcare decisions for the individual in the event of incapacity. The presumption is that the person named as having the healthcare power of attorney for the person will act in the individual's best interest and try to carry out his or her wishes in the event difficult healthcare decisions must be made. This particular power of attorney for healthcare is different from a general or financial power of attorney that gives a person control over the impacted party's financial and other legal affairs. Lastly, most EMS providers are very aware of do not resuscitate orders that apply when a patient enters a pulseless, non-breathing state. Some states, like Wisconsin, require the patient to be wearing a do not resuscitate bracelet to convey his or her do not resuscitate wishes to EMS providers. Some states give medical control the ability to accept other types of do not resuscitate orders as well. Additional legal provisions often recognize that a DNR order is not the same as committing suicide, which could impact life insurance or other related benefits or contractual relationships. Legal liability protection may also be afforded to EMS providers who follow DNR orders in good faith. Unfortunately, many of these laws are not necessarily written with EMS providers in mind, and complicated scenarios are too easy to identify. In Wisconsin, for instance, DNR orders are valid for EMS providers only when the patient is wearing a statutorily mandated bracelet. If an EMS crew responds to a nursing home where the bracelet is attached to the patient's chart and not the patient him or herself, they should technically begin CPR even if they know it is against the patient's wishes. Another shortcoming of the Wisconsin law is that there is no guidance on what to do if a person has an out-of-state order. Children under the age of 18 are also not eligible to receive a DNR bracelet, even though there are cases within formal healthcare environments where children are no codes given a serious and unfortunate terminal illness or condition. With more of these children receiving in-home hospice care, an inadvertent 911 call for that child could put the EMS crew in a very difficult position. Given significant differences from state to state in the legal provisions governing end-of-life decisions and advance directives, EMS students and providers are strongly encouraged to seek more information on the topic through additional education and training from their own EMS agency, an attorney in their jurisdiction who is familiar with the EMS and end-of-life issues, or any combination of these resources. For the time being, however, you should now be able to generally explain advanced directives and how they impact patient care within the EMS environment. This presentation was prepared by Waukesha County Technical College in Pewaukee, Wisconsin, and is distributed with an Attribution Non-Commercial Share-alike 4.0 International Creative Commons license. Copyright 2019 Waukesha County Technical College. For information on WCTC's numerous fire and EMS educational offerings, please visit us online at wctc.edu.